Record.
Welcome, LA Progressive friends, family, readers, viewers. Today, Dick and I are once again delighted to sit down and have a chat with Bill Blum. Bill Blum is so gracious to offer us his brilliant writings. And today we're going to be talking about a piece that he wrote called The Whole World is Watching. Bibi is getting crazier. So Bill, if you would, just introduce yourself and let's dig into this piece that you wrote.
Okay, so I'm Bill Blum. I'm a retired judge and a writer. I'm a part-time lecturer at USC and UCLA, and I write on the intersection of law and politics on a variety of topics. Recently, I've been writing on the rise of Donald Trump, and even more recently on the war between Israel and Hamas, because international law has been an area of interest to me for a long time, since the middle 1980s, when I went to the International Court of Justice to cover the case of Nicaragua versus the United States. And I've kept that interest ever since. And my most recent column is on the case brought in the International Court of Justice by South Africa against Israel under the Genocide Convention of 1948. And my goal in writing articles like this is to explain what the court is and what this case is all about, and then to try to give a balanced presentation of both sides on this case, because it was a fascinating oral argument that stretched over 2 days, January 11 and January 12, before the International Court. The International Court of Justice is sometimes called the World Court. It's the principal judicial organ of the United Nations, and it meets in the Peace Palace, which is this massive red brick neo-Renaissance style mansion that's located in The Hague, Netherlands. It was built with funds provided largely by Andrew Carnegie, and it's managed even to this day, the property, by the Carnegie Foundation. And the judges of the court come from all over the world. There are 15 permanent judges at any time, and each country that's involved in what's called a contentious case, if they're not already represented on the court, get to put an ad hoc judge on the court. And that's what was done for the oral arguments, one judge from Israel and one judge from South Africa. So with that kind of preface, let me just add one other thing. This is a court of limited jurisdiction in a very important sense. Unlike a domestic court, which has jurisdiction, say the Supreme Court, over any kind of federal issue, the International Court of Justice really is a voluntary body. Every member state of the United Nations belongs to the ICJ, the International Court of Justice, but not every state accepts the compulsory jurisdiction of the court. In fact, only 73 countries do, and they don't include Israel. They don't include the South Africa either. So the cases come to the ICJ in a variety of ways. One is in a case that involves countries that both accept compulsory jurisdiction. So if country A and country B say, we want to submit in all respects to the jurisdiction of this court, then those two countries can have a matter heard before the International Court. Another way is to bring an advisory opinion, an advisory case before the court, and that's generally done by the General Assembly. The General Assembly of the United Nations determines that there's a very important issue that they want an opinion on to give a statement of international law. And that's not binding, not even formally binding, but that's another way that you can bring an issue to the court, even involving a state that doesn't accept compulsory jurisdiction. And then there's a third way, which is the way that's being done in this case, and that is to do it through an international treaty or a convention that both states have signed and have agreed to submit to resolution to the ICJ. And that's what this Genocide Convention of 1948 provides. Article 9 of that convention says that the state signatories will submit disputes arising under the convention for resolution to the International Court of Justice. It was only recently, in 2022, however, that the court extended standing to a country like South Africa, which wasn't a party to a conflict. And that happened in a case involving Gambia, or the Gambia, versus Myanmar, involving the alleged genocide against Rohingya Muslims. And that was the first time the court recognized that a party to the Genocide Convention could bring another party to the convention before the court, even though the initiating party wasn't part of that war, under the theory that every member of the Genocide Convention, every member state, has an obligation to abide by the convention, and each state can bring another party before the ICJ on allegations that the second party is violating the terms of the convention. So with that preface, please ask any questions that you have.
Right. I'm interested in this issue about compulsory jurisdiction. I think you say that 73 countries around the world submit to this, agree to this, so that the World Court can do full action on them. I assume also the United States does not submit to that.
No, we don't.
And
no, we went through with it from it in the 1980s with Nicaragua.
What was that? I talked over you.
In the mid-1980s, Nicaragua sued the United States because we were mining their harbors, and the United States just refused to participate in the case at all. I went to the court for that case, and there was no American representative. So we don't submit to the compulsory jurisdiction of the International Court of Justice, and neither does South Africa.
Where I was going with that is say both Israel and South Africa were party to the compulsory jurisdiction. What more could the court have done? Could it actually somehow order a ceasefire, or what additional actions would be available to it?
Well, it could do many things. Since the basis for jurisdiction in this case is the Genocide Convention, the issue going forward will be, is Israel committing genocide? Right. It's not going to be, is Israel committing discrete war crimes? So let me give you a hypothetical using the United States. Let's say that during the Vietnam War, the United States abided by international humanitarian law in all respects, except for the My Lai massacre. The My Lai massacre would still be a war crime, but the United States wouldn't be susceptible to an accusation of genocide. So think of the genocide as the granddaddy of all war crimes, and it includes discrete war crimes, but the court is not going to be passing judgment on discrete war crimes. It's going to use the number of war crimes that have been committed to decide whether or not this overarching crime of genocide has been committed. And that gets me into what is genocide. Genocide's defined by the convention. It's defined elsewhere. You can find a definition of genocide not only in the convention, but say in the statute of the International Criminal Court. There are many different documents, and they all use basically the same definition. And like all crimes in the United States, there are two halves of an international crime like genocide. There's the physical act, which would involve killing or creating conditions of life that are conducive to the destruction of an entire group. And then there's an accompanying mental state. So just as, say, in the case of a homicide in the United States, it's not enough to convict someone of murder simply to show that there was a killing of a human being, that is the act of homicide. You have to show an accompanying mental state, such as a specific intent to kill or premeditation for first-degree murder. So in genocide, you have to show that there's a specific intent on the part of the accused state to eliminate, in whole or in part, a nation, religious group, or an ethnic group. And that's the harder element of a genocide to establish. So that's the burden that South Africa has here. And the other thing to keep in mind is that this is just a provisional preliminary hearing. This is not the hearing on the merits. The hearing on the merits will not take place probably for 2 or 3 years. Consider the case of Ukraine and Russia. The provisional measures, the preliminary hearing in that case was heard in February of 2022. The court handed down a ruling on the provisional measures, that is a preliminary decision, but it's still hearing the case on the merits. It hasn't issued any decision on the merits. So the burden in the preliminary context is much lighter than it is in the permanent context. So when a state like South Africa comes in and says, we have to have provisional measures to prevent genocide in Gaza, the burden is only to show that the allegations are plausible, not that they are conclusive. And the International Court of Justice does not have a body of law behind it. It has a statute. It has a body of law behind it, but I was going to say not as extensive as, say, the United States Supreme Court. It only has 192 contested cases in its entire history. It has a statute. It has rules of court. And at this preliminary stage, the standard of proof is much lower than it will be later on down the line. So that's an asset for South Africa in its presentation. It only has to show plausibility for the court to say, yes, we have jurisdiction over this case, and you've made a plausible showing that we have to intervene to prevent irreparable harm, and we're going to now order certain preliminary steps to take place. And then South Africa is requesting a number of preliminary steps, what are the equivalent of a temporary restraining order or a preliminary injunction in US law. They're called provisional measures in the jargon of the International Court of Justice. So that's kind of the rough framework that we have. And each side is allotted 3 hours of oral argument on a provisional measure hearing. South Africa delivered its oral argument January 11, Israel on January 12, and they put together a legal team. The legal team is headed by what's called an agent. An agent is like the lead counsel in a big lawsuit in the United States. The agent is a representative of the state, however. So South Africa had its representative, had its ambassador to the Netherlands, and Israel had its counsel to its foreign ministry be their agents. And then they had an array of attorneys, very distinguished international law experts on both sides. The hearings were live streamed, and I watched them in their entirety on a Zoom hookup. 3 hours of argument on both sides. I will say that both sides did a really good job at representing their clients in this case. And it's important for me when I write an article on this, I'm particularly explaining the procedures of the ICJ. I want to be fair to each side and credit them with the strengths of their arguments. We all want to see this horrible, horrible war come to an end, and want to see to what extent the ICJ can help bring that about. Now, one of the questions people have is that to what extent are ICJ rulings enforceable, whether provisionally or in a permanent way? And the answer, unfortunately, is that they're not really very enforceable. If you look at the Russian situation, for example, and this is one way that the ICJ does move into action very quickly. with provisional measures. So Ukraine filed an application for provisional measures against Russia. I think it was on February 26, 2022. The ruling on the provisional measures came out March 16. That's really fast. Now, unlike Israel, Russia boycotted the oral argument, so it wasn't even represented there. And its longtime counsel at the ICJ, a man named Alain Palais, a French international lawyer, who I met back in the 1980s in this Nicaragua case, he withdrew from from representing Russia at that hearing, just didn't want to represent them anymore. In any event, the ICJ handed down a set of provisional rulings which ordered Russia to cease and desist from all military operations. And we all know how that went. Immediately after that ruling was issued, Russia stepped up its attack on Ukraine and hasn't stopped. So that hasn't helped end the hostilities. However, these rulings handed down by the ICJ carry a lot of moral authority. And unlike Russia, Israel does care about world opinion. Otherwise, it wouldn't have participated in these proceedings. It just would have boycotted them. And so I think it's very important that we pay attention to what these provisional measures are that come out of this hearing. I think we'll have them probably by the end of the month. It will be very interesting to see the Israeli response. What they tried to do at their oral argument was to have the entire case thrown out at the jurisdictional stage. I don't think they're going to succeed in doing that. But on the other hand, I think that the provisional measures that South Africa is asking for are not going to be granted in their entirety. But, and I say that in the piece, I think that I doubt the ICJ is going to order Israel to stop all military activities simply because the other party to the conflict is not before the court. And that's one of the other limitations of the ICJ, is that it only has jurisdiction over state actors. It doesn't have jurisdiction over non-state actors. The tribunal that does potentially have jurisdiction in this case over Hamas and, of course, Israel is the International Criminal Court, which is investigating the war. And I have a high degree of confidence that there will be indictments issued by the ICC. It doesn't move with the speed that people would like to see it, but it will be moving. I'm quite confident of that. The ICC indicted Vladimir Putin. Now, just to give you a sense of the international landscape, however, because people, particularly on the progressive left, think of South Africa as the current South Africa as the ANC of Mandela, and they think of it as a stalwart of international law. Well, with regard to the ICC, the nation of South Africa under the ANC has a pretty spotty record. It was rebuked by the ICC for failing to arrest the president of Sudan in 2015, who had an arrest warrant out for him. And the ANC tried to withdraw from the ICC, but the Supreme Court of South Africa overruled it and said, no, we don't want you to withdraw. So it remained in the ICC, but it refused to carry out the arrest warrant issued by the ICC. It also did something similar with Putin very recently with a conference that South Africa was hosting. Excuse me for a second. This summer, Putin wanted to visit South Africa. South Africa wanted Putin to come and participate in a conference. And the ICC said, you have to arrest Vladimir Putin if he sets forth on your territory. You're a member of the ICC. Again, South Africa threatened to withdraw from the ICC. It said, we're not going to do that. That would be equivalent of a declaration of war on Russia. The situation was defused with Putin deciding, okay, I'm not going to go to South Africa. I will appear at the conference via Zoom, which was what he did. So let's get back to so South Africa is a member of the ICC. Israel, of course, is not a member of the ICC. So you have two state parties with kind of checkered histories with regard to international courts. Israel, of course, doesn't accept the compulsory jurisdiction of the ICJ. It's not a member of the ICC. It's appearing before the ICJ in this case in order to avoid becoming more of an international pariah as far as international law is concerned. So there's a lot of politics that are going on in this case before the World Court. And there's also a lot of law. So I try to explain the intersection of the two for readers and try to make it hopefully understandable to people who aren't lawyers. And that's my goal. I hope I did that with this article, but ask away if you think there are more ambiguities that we need to clarify.
No, I think you did a very good job. I'd like to go over a couple of the things and
Sure.
offer what most people would be familiar with. For example, in domestically in the United States, we have a body called the legislators, and they write the law. We have a body called our courts, and they interpret the law. And then we have a body called law enforcement that enforces the law. And so it seems to me that the enforcement part, regardless of what the ICJ determines and regardless of what the ICC determines, the enforcement part is what's lacking. Does that sound like that would be accurate?
Yes, that is true. With regard to the ICJ, a party can seek compliance through the Security Council of the United Nations. If you're a small nation and you're not complying with an order of the ICJ, the Security Council and the UN as a whole can implement sanctions against you to force you. If you're a big heavyweight like the United States and Russia, you can simply disregard it and you have a veto. And that's the end of it. There individual countries can impose sanctions on you, but if you're big enough and strong enough, you can get around them. So you're right. The enforcement part is entirely missing. And that's because international law is basically consensual. And it's a kind of a might makes right situation where the biggest, toughest guy on the block generally gets his way, unfortunately.
Yeah.
So let me touch a little more on these ICJ rulings that have great moral weight and can't easily be ignored. And Israel would not like an adverse ruling against it because it would further damage its reputation around the world. But practically, to end this horrible war in Israel and Palestine, what difference would an adverse ruling make? What actions might Israel take in response? And how could the United States, which is all wrapped up in this, get further wrapped up?
Well, that's a great question. And we'll have to see what the specific provisional measures are. But I think it's going to increase the pressure on the United States to tell Israel that it simply cannot do certain things in its efforts to defend itself if it wants more U.S. aid. I don't think the United States are going to cut off aid, but there's a big difference between giving Israel $14 billion in aid and, say, for example, giving it $1 billion. Huge difference. So it may cut back the amount of aid. And other countries around the world will follow suit. One thing I will say about the rulings of the ICJ is that they're detailed, they're really very, very well reasoned. And what you're going to see with these provisional measures, this is a prediction, of course, I could be wrong. The ICJ issues a majority opinion. It's not signed. It will indicate the vote. And then dissenting judges or judges who want to write the equivalent of a concurring opinion can do that. And they're separate opinions. But the majority opinion will be the one that says, these are the orders, Israel, that we expect you to carry out now. And there was an interesting piece in a website called Just Security, which attracts writers who are mainstream experts in international law. And what I was pleased to see is that the author of this particular article was predicting and urging certain orders that track ones that I said that I think the court is likely to issue. I don't think they're going to issue an order that says, Israel, you cannot defend yourself, which incidentally was something that one of the lawyers who represented South Africa at the January 11 hearing, he's a respected international lawyer named Vaughn Lowe. He was arguing, and I think that was just an overreach on his part. The court is not going to say that Israel doesn't have the right to defend itself. But I think probably they're going to come up with an order that says, you shall not commit acts of genocide, including but not limited to, and then list certain things. Bombing civilian infrastructure, bombing hospitals, and things of that nature. I think they will further order Israel to allow more humanitarian aid, and that they will be more specific than just using the word more. It'll be quantified in a certain way. I think they may order Israel to file progress reports on how they're complying with these orders. I think that they will likely order Israel to allow human rights organization observers and reporters to have greater access to Gaza, because that's one of the big problems. If you try to follow what's actually happening on the ground, as I try to do, and I read Al Jazeera and I also read the Israeli press, I read it every day. This isn't something I used to do on a daily basis, but I read it. I try to get as granular as possible. There's just a dearth of on-the-ground reporting. For example, you don't see Richard Engel in Gaza reporting for NBC from one of the hospitals, because the IDF doesn't allow that. The IDF has very closely curated reports, and they'll show you tunnels. I don't have any reason to think that what they're showing you is fake, but they're showing you what they want you to see. So I think that the ICJ will probably order that. And I think that there's a good possibility, and this is what the Just Security website suggested also, is that they will probably order South Africa to use its influence with Hamas to encourage Hamas to release the Israeli hostages. So I don't think when you bring a case before one of these international tribunals, you are kind of opening the door to a wide array of orders that the court can issue. And that could apply to South Africa too. You could see it more directly in a case like Ukraine versus Russia, because one of the provisional orders issued in that case was that Ukraine, you shall do nothing to contradict or counteract the other provisional orders that we're making in your situation. The big order there was Russia, stop your military operations, but they also ordered Ukraine not to do anything. They can order Hamas not to do anything because they don't have jurisdiction over Hamas, but they do have jurisdiction over South Africa, and South Africa, for better or worse, has a relationship with Hamas, and they may very well order South Africa to use whatever leverage influence it has to encourage Hamas to have a ceasefire, or to encourage Hamas to release hostages, which I think would be a good thing. Overall, though, I think that the Israelis will protest any any exercise of jurisdiction in the case. That's their number one request. We want you to dismiss this case. They'll get another opportunity to do that after the provisional measures are ordered. And that's the way that the body works. And that's why I said that it usually operates at a snail's pace. Because after the provisional orders are issued, what will happen is that they'll move to a phase where they'll entertain what they call preliminary objections. And those are motions that will be made by the parties. And then they'll also allow other state parties to intervene in the action and to give their side of the situation. And in the case of Russia and Ukraine, there are 32 separate countries that have intervened in that lawsuit. And that's going to take a long, long, long time. It will take too long, obviously, because people are dying and Gaza is being leveled and there are attacks going on there are rockets still being launched into Israel, and there are 150 hostages who are still approximately in Gaza, held by Hamas and Islamic Jihad, and nobody has access to them. And one of them is as young as a 1-year-old infant. So it's a terrible situation. We want to get it resolved. These courts are part of a package of tools that people have to bring about the desired result. So I like these international bodies. I'd much rather see Israel, South Africa, and to the extent possible, non-state actors come and argue and duke it out in court rather than bombing each other in the real world. So while there's bound to be some disappointment in the results of this, with the results of the ICJ case, I want people to understand that it's better to have these international bodies than it is to simply throw up your hands and say, there's nothing we can do.
So it seems to me that, and I agree with you, I think that it doesn't hurt to have these international bodies. But with Hamas not being under the jurisdiction because it's not a state actor, do you feel that there are state actors? Because Hamas doesn't really have a voice in this process.
No, it doesn't. In Palestine, it's interesting because Palestine's a member of the ICC, the International Criminal Court, but it is not a member of the United Nations. It has non-member observer status. So one of the things I've been wondering about is, to what extent can Palestine intervene? And who would intervene on Palestine's behalf if it did? Because the Palestinian Authority, basically, from everything I've been able to gather, doesn't have much control over either Gaza or the West Bank. It's all Hamas in Gaza, and I have no idea who's calling the shots in the West Bank. So you're right. It's a very limited situation, and I look forward to seeing these provisional measures. I look forward to seeing the reasoning of the court, and I think it will give human rights activists another way to pressure the Biden administration, to pressure Israel to abide by international law. And I think that that's a good thing. And it doesn't mean that you don't have other forms and avenues of protest. I mean, people are protesting, and I think that that's a good thing in general. I think, as with any protest, there are some people who go a bit overboard, and the point is often made that anti-Zionism is not the same as anti-Semitism. I've always believed that, but sometimes overzealous people cross the line, and who, in an effort to help the Palestinians, start targeting Jews in ways that have very little relationship to the conflict between Israel and Hamas. But so there are many different avenues to pursue to end this conflict. And of course, political pressure on the Biden administration. And then that brings us to, the 2024 elections. Assuming this conflict continues, and it's a good reason to believe that it will, what do people do? Do they vote for Joe Biden and more of the same, or do they vote for Donald Trump, who's threatening to be even more of a hawk on behalf of Israel? It's a really tough call, and people have to think that through.
Well, this has been wonderful, Bill. Thank you so much. We're with you on praying that the Middle East, Palestine, Gaza, Israel can come to some conclusion in the near future, and your deeply involved examination of the World Court may help that. So we look forward to getting this out to our audience and talking to you the next time.
Yeah, and my hope is that
Can I
that
add
we
one last-
share this, and we're asking people to share this video using social media, because you're not going to get these kinds of messages on mainstream media, and people need to know about this.
Let me add one last thing. I think one thing that we can do, and I've said this to you before, I don't think there's going to be peace in Gaza until Bibi and his cohorts are gone. And I think that when we talk about pressure, there's pressure within Israel, there's pressure in the United States to bring about his departure. And I think that the decision by the ICJ will help bring that to pass. And I want people to understand that. That's a concrete goal that I think is achievable.
I
And
agree.
he went to my high school, so you know what? That's too bad.
Yeah, you've told us you went to high school.
Thank you for sticking around. If you like the LA Progressive content and the discussions we have here, please consider clicking the subscribe button below, and also give us a thumbs up. That helps to grow our audience by feeding the algorithm, which helps to get this content in front of more eyes. Thanks for stopping by. We really appreciate your support.